This committee shall come to order. First, we'll get some housekeeping things out the way, and then we'll start getting bills. Need a motion to refer House Bill 322 to general laws.
So moved.
There a second?
Second.
Please open the vote. Well, I'm sorry. First of all, let's do roll call first. Open roll.
Mr. Chair, you have a quorum.
Thank you. Now that we have an official quorum,
Now, Mr. Chair, I move that House Bill 322 be referred to general laws.
there's a motion and a second. Please open the vote. Next, we have House Bill 324 and House Bill HB 326 by Delegate Glass. They both need to be referred to Ed and Health. Is there a motion?
So moved.
Please open the vote.
Ayes 12, noes 1.
Ayes 12, noes 1. Thank you. Next, we have identical bills that reported unanimously from P&E in the House. They have Signet Cotniks. That is HJ 45, Constitutional Amendment, and HB 558 is also a Constitutional Amendment on the second reference, and both need to go to Finance. Is there a motion to report for the
So moved,
first?
Mr. Chair.
Refer to finance. Make a motion.
Please open the vote.
Ayes 13, no 0.
Don't do this until Carol gets here because we're leaving right now.
Okay. Thank you. Next, we have House Bill 1346 by Delegate Bloxham, and that is identical to Senator Obenshane's bill. And I believe they adopted the amendment that we had. Is there a motion to report?
Move to report.
Please open the vote. Thank you.
Ayes 14, no 0.
Thank you. We have is Delegate Sickles here? All right. Do we have? Thank you. Next will be.
There's Delegate Sickles right there.
Thank you. Please come up, Delegate Sickles.
Okay, Mr. Chairman, I have 3 bills here today, so.
Sure. You have House Bill 730 in front of us now.
Just move that one, right?
Did we? No, we didn't move that one yet.
Move the report.
Second.
House Bill 730, we didn't move that one yet. House Bill 730, it is the same as Senator Perry's bill. It's identical. We heard that. Is there a motion to report?
So moved.
Please open the vote.
Ayes 14, no 0.
Delegate Sickles, you also had House Bill 1177. We'll hear that in a moment. Just wanted to make sure you were here, sir. So if you could have
Mr.
it.
Chairman, I think there's an identical bill in your body on that too by Senator Van Valkenburg.
Okay.
Okay.
Yes, and if that bill reports, it has to go to Finance. There's an identical bill. I know members, this was a contested bill in both chambers. We've heard this bill. If you want to give us a brief overview of this bill. It is identical to Schuyler Van Valkenburg's bill. We heard that already, but just for the sake of the
Yes,
record.
Mr. Chairman, just tell me when to stop, but the administration, without warning to us or any indication that they were having issues with the ERIC system, which we helped start here in Virginia, they resigned from it, and it was a very cost-efficient way to share information between states. And this bill requires us to join back up. It's very cost-effective. I can read you what the report said.
No, you don't, there's no need for that. Thank you. Thank you, Delegate Sickles. We have the motion to report refer to finance. Please open the vote.
Two noes.
Ayes 8, no 7.
Thank you, sir. Now we're on to similar bills reporting. We'll come back to you, Delegate
Okay,
Sickles.
I got one more. Thank you.
Now, HB 55, Delegate Wright, primary elections, candidates for nomination, withdrawal of candidacy. They're similar, and they will adopt the House version of this bill. So is there a motion to report?
Move to report. Second.
No, we don't have to conform this one. So please open the vote. Next, we have,
Ayes 14, no 1.
thank you. This is similar to sewer line bill that we heard before, our committee, House Bill 90. And we do need a motion to conform the two to the Senate. So motion to conform, House Bill 90. To SB 109. There's a motion. Is there a motion to report the substitute? Second. Please open the vote. Next, we have HB 441, Bennett Parker. Polling places, I believe Senator Van Valkenburg had a similar bill, if I'm not mistaken, or Senator Subramani had a similar bill, and we do not need to conform this. They will conform it on the House side. And so we've heard this bill previously.
Move to report. Second.
Please open the vote.
Ayes 15, no 0.
Thank you. And now we're on to uncontested bills in the House.
Delegate Price's bill's going by for the day, is that correct?
That is correct. 904, HB 904 will go by for the week. Now it should be on uncontested in the House. Yes, 904 is not on there, so it's going to go by for the week. We've updated it since then. Now with HB 69, Bolivar bill. Good afternoon, sir.
Thank you, Mr. Chairman. So House Bill 69 is a measure to just provide some transparency and a little bit of sunshine on the process for making interim appointments where a vacancy occurs on a local governing body. And so currently, as you know, if there's a vacancy on a town council or a board, the code allows for the remaining members to appoint an interim member. And so while that's clearly important in terms of being able to continue the operations of government, when you think about it, it's probably one of the most undemocratic things that we do to allow people to pick other folks to sit on their councils. And those votes can make a difference with respect to the outcome. I was actually surprised, quite honestly, that there are no guidelines in the code with respect to transparency or any kind of opportunity for public input. And so while most of the time the process does go smoothly, you just have to do a quick Google search and you realize that sometimes these things don't go as smoothly as planned. And so what House Bill 69 does, it doesn't impede the ability of the councils to select whoever they want, but it does require a 7-day advance notice when a person is proposed to fill a vacancy and an opportunity for public comment. And that way, if there are any public concerns or if the public has any comments, those can be considered before rather than after the selection has been made.
Senator Deeds.
Delegate Boulevard, have you had conversation with localities, local governments to find out whether there's, my experience is most localities that I know, when they have this issue come up, they do give notice and everybody knows about it, knows who the candidates are. but this doesn't impose any sort of burden that you've heard anything about, does it?
In terms of whether some localities do or some localities don't, and I do have Megan Ryan with the Coalition for Open Government who can provide a little bit more detail, but I can tell you from my experience with my own locality is that they don't give advance public notice. They just make the appointment. But I think the point is that the code doesn't require any kind of advance notice.
Mr.
like
Chair, that just goes to the point. There's all kinds of trouble in Northern Virginia.
There is lots of trouble in Northern
Lots of trouble
Virginia.
in Northern Virginia.
Thank you. So, is there anyone in opposition of this bill? Not seeing it. Is there a motion?
I'll move the report.
Second. All right, please open the vote.
Ayes 15, no zero.
Thank you, Delegate.
Thank you,
House,
Mr. Chairman, and well set up, Mr. Deeds.
thank you, sir. Is Delegate Sullivan here? Okay.
I move we pass the bill by indefinitely.
All right. There's a motion and a second? Okay. Okay, you revoke your second. All right. Delegate Watts,
Come on, man.
you have House Bill 126.
Yes, I do. Thank you, Mr. Chairman. House Bill 126 is really quite simple. It says that if you have not filed at least one campaign report in the year that you are on the ballot, your name will not appear on the ballot. It quite frankly puts some teeth. We're very firm about all the deadlines that what you have to do to qualify to be on the ballot with your statement of economic interest and the number of signatures and your all of these things. But I really believe that the campaign finance report is a very important public information instrument, and this puts a little bit of teeth into people knowing what the candidate situation is.
Mr. Chair.
Thank you, Delegate. Senator Deeds.
Delegate Watts, are there offices for which you don't have to file an economic, a statement of campaign finance report? I'm thinking about Soil and Water Conservation District for specifically.
And this is why it reads that who fails to file at least one CAM finance report that it is required in the election year to have his name on the ballot. So if there are such elections, this would not apply.
Okay.
All right. Sorry. Senator Van Valkenburg.
Thank you, Mr. Chair. Mr. Chair, Delegate Watts, so if somebody goes through the work of getting all of their signatures and getting all their ballot access, and they get on the ballot access properly, and then they don't file one of these, they should be taken off even though the people want them to be on the ballot?
And I would say, Mr. Chairman, I would answer Senator Van Valkenburg that, again, I'm going to underscore our campaign finance report information is very important part of public accountability of who's on the ballot. I take it seriously, particularly when we have some of the issues about campaign finance in Virginia. So that information, or even the lack of the information, it doesn't say that it has to be timely, doesn't have to be accurate, but you at least have to file it. And I have been told by those who oversee the campaign finance reports that this also fills a gap in their knowing who's supposed to file. Because in an election year such as we just went through, when you have thousands and thousands of people who are supposed to file, people who don't file just simply fall through the cracks, and any penalties that we may have as far as monetary don't get enacted because you don't even know that they were supposed to file. It closes a loop of who's on the ballot and the seriousness of filing at least one campaign finance report.
Thank you, Delegate Watts. Are you, Senator Perry? Do you have a question?
I have a question, Mr. Chairman, and I apologize, I wasn't here for the previous question. But my question relates to the way that I read the bill. It says that you need to file a campaign finance report if you're running that year by July 20th. Is that right?
This was done at the request of the registrars, that was the time frame that they needed to properly prepare the ballot.
And Mr. Chairman, if I can just follow up, is that
Perry?
I went and looked at the filing deadlines for 2024, and it looks like the deadline, if you want to run as an independent candidate in 2024, the deadline to file that you're running is August 23rd, 2024. And so I was wondering how those two things go together. If I have to file a campaign finance report, but I still have time to decide whether or not I'm going to run or not.
Mr. Chairman, I would say again, in talking with the registrars, that the way this is worded, that you are required to file. So in that case, you weren't required to file one by July 20th, so your name would still appear on the ballot.
Thank you. Is there anyone in opposition to the bill? Do you have anyone online? Okay. Is there anyone here in support of the bill? Is there a motion? Move the report. Is there a second? Second. Please open the vote.
Ayes 8, no 7.
Thank you, Delegate Watts. We have HB 742 before us now. Thank you. Is Delegate O'Quinn here? Don't see him here.
Move PBI.
Delegate Shin.
Had a second.
Is Delegate Shin here? Okay.
Move PBI.
Delegate Anthony, I see you here. You're next on the list. HB 1003.
All right, thank you, Mr. Chairman, and many members of the committee.
That's right.
HB 1003 mandates
Sorry.
that any changes in the election district precincts or polling places must be communicated to affected registered voters by mail at least 13 days. This is a change from 15 days. This is a particular constituent bill that impacted a particular precinct in my district where their polling place was changed 4 times within 2 years, and which impacted them with voter disenfranchisement and voter dilution. And so we just want to make sure that most registrar's offices are very good. As soon as electoral board and board of supervisors or city council makes that decision, they send out a notice. But we want to make sure that we alleviate any of the errors that may occur with USPS, that we change it to 30 days.
Thank you. Is there anyone here online or in person in opposition of the bill? One in opposition, ma'am. Please make sure your camera is on, and you have 30 seconds.
Shelley Oberlander.
All right. She's not on. All right. There's someone here in person in opposition to the bill. Is there a motion? There's a motion. Is there a second? Please open the vote.
Ayes 15, no 0.
Thank you, Delegate Anthony.
Thank you.
I know you have a couple more bills, but we'll get there in a second. Thank you. Next, we have HB 1171. Delegate Watts. Am I pronouncing his name right? Waxman.
I'll make it easy, like Waxman, Waxman.
Delegate Waxman, thank you for being here, sir. You have HB 1171.
Yes, sir. Thank you, Mr. Chair and members of the committee. We did put an amendment in that should be in the system from yesterday.
Mr. Chairman, it's online.
It's online. Is there a motion to move the amendment? Is there a second? All in favor?
Okay, for those of us who aren't online, could you report the amendment?
Yes. Can you report the amendment?
Yes, at the very bottom, the end of the bill, that when we did the update, there was some language put in that when someone was duly notified that their ballot needed to be cured, we just took out the word duly notified, and there was an issue with that because we discovered if a voter wanted to cure their ballot, but the registrar had never notified them that it needed to be cured, we didn't want the registrar to not allow them to cure it.
Is there anyone here in opposition of the bill? Do you have anyone speak in support of the bill?
I was talking about the amendment. The purpose of the bill was to specify that when the registrar's office gets the absentee ballot, they've got 3 days to review it. That's the new part. Mm-hmm. And then once it's incomplete, then they've got the usual 3 days to notify the voter that it needs to be cured. We've not heard, we did get support from the Registrars Association. I had one group that was concerned about not having 3 days not being enough time to review the ballots when existing code actually says they're supposed to review it upon receipt of it. We're just clarifying it so voters get notified that they need to cure it so those ballots don't become provisional and not counted.
Delegate, where did the 3 days come from? Was that just a number? Where was that number recommended from?
Originally, it was to get the time period through because when you get to within 10 days of elections, if you go more than 3 days to identify the problem, 3 days to notify the voter, if you go past that, the voter doesn't have time to come back to the registrar's office and cure the ballot, so it becomes a legitimate ballot on election day instead of a provisional ballot.
Okay.
And I think I may have some people here.
You have someone speak in support of the bill? All right, sir. You have 2 minutes.
Mr. Chairman, members of the committee, David Bailey on behalf of the Voter Registrar Association of Virginia. The initial bill did have 2 days, and the registrars requested 3 to give a bit more time, and are fully in support of the bill.
Okay, thank you, sir.
Sorry. Cleber Wheeler, Albemarle County Electoral Board, speaking for myself. This is a bill that helps the registrars make sure that they notify anyone whose ballot needs to be cured. So the ballot envelope is not left in a basket waiting, so that if they need to be cured, the voter knows they need to cure their ballot, and they'll come in, and it won't be left.
All right, we have one online. Please make sure your camera is on, and you have 30 seconds.
Shelley Oberlander, please unmute, turn your camera on and begin.
Hey, I'm trying to let you see me, but I'm here, and we do support this bill. We support the general registrars, and we ask that you give them the time that they need to contact the voters, as the previous speaker said, so they can come in and cure their ballots. It helps the voters, it helps the whole process, so it helps to have the extra time for the general registrars. Thank you.
All right, thank you.
Sarah Bell is the one that had the problem with this bill.
All right, thank you, Delegate. Is there a
I just have a question, Mr. Chairman. Delegate Waxman, we received some information from Fairfax County, and I was trying to scramble through and look through your amendment and sort of see how that changed things, that they were concerned about the 3 days. They said they often get, 6,000 ballots a day, and so being able to get through them that quickly would be problematic for them. Have you had any conversations with them?
I did, and actually there were 2 things that they did. One was that issue, they wanted to make it more than 3, and I explained that we went from 2 to 3 at the recommendation of the Registrars Association. I also explained if we get more than 3 on the front end and 3 after they notify, then we run into issues where those voters that vote on the 10th day before the election, you throw a 2-day weekend in there, they're not being notified in time to come back in and cure that ballot. The other thing that they did, it's their discussion that got us to realize we had a problem with that duly notified wording. So we amended it to take care of that second problem. The other registrars that we've talked to, they seem to not have a problem with the 3 days. What we're trying to do is just specify, to be clear, to get to the intention of the original language, that they do this in a prompt method so voters have the ability to come and cure those ballots in time so their vote counts.
Mr. Chairman,
Senator Perry?
if I could just follow up. So is it, I understand the intent of the bill, and I applaud the intent of the bill, right? We want to get voters in, we want to let them know if there's a problem, we want their votes to be able to count. I applaud all of that. But it sounds like I think Fairfax is still the largest jurisdiction in the state. And it sounds like they still don't think those 3 days is going to be enough time. And I know you said, I'm a lawyer, so my math isn't that good. but 3 + 3 would be 6, and even a 2-day weekend, you said 10 days beforehand, that's still an extra 2 days. And so I'm just curious, is it still the case that Fairfax is still opposed to the 3 days?
I believe they are, but I think I've been told Fairfax has quite a number of satellite voting locations too, which means that they have a lot of staff that should be able to do that during this time. With that 10-day period, you've also got to count that the time it takes for the ballot to get from the mail to the registrar's office too. That could take a couple days as well.
Mr. Chairman.
Yes, Senator Perry.
But there are days built into the calendar that relate to, when bills have to arrive and when they can continue to count post-election day. Is that right?
I thought there was 10 days before election was when it had to be postmarked to get to the registrar's office.
No.
No? Okay.
So, Delegate Weissman, we have a motion and a second before. Is there a substitute motion? Is there another motion?
Sure.
Senator DeStaff.
I feel that this is one that probably needs a little bit more work. Can we take this one by for the week?
That is all right with me, if that's okay with you.
Okay, sure.
All right, so this bill will go by for the week.
Thank you, Mr. Chair.
Thank you.
We've already killed you, Bill. We've already killed you, Bill.
Who's that?
Sullivan.
All right, Senator Sullivan.
I don't know if that's a promotion or a demotion, but I'll just.
And you have HB?
HB 111.
Yes.
Thank you, Mr. Chair. I apologize. I was in another committee meeting. HB 111 comes to us from the Uniform Law Commission, which I'm sure everyone on the committee knows is a group of eminent lawyers from all around the country that draft legislation directed at trying to get the 50 states, in some cases, to get their laws uniform. The most famous, of course, is the Uniform Commercial Code. HB 111 is the Uniform Faithful Presidential Electors Act. And it's a very simple bill. I know it looks like it's a long bill, but it's really not. It restates existing law except for the fact that it requires that after a presidential elector takes his or her oath to cast their ballot in the Electoral College for president and vice president, it directs that he or she must do so, must live up to that oath, and anyone who refuses to do so in violation of that oath is deemed to have vacated the office and are replaced pursuant to the act. I want to disabuse anyone of the notion this has anything to do with recent American politics. This Uniform Act has existed for, I think, 15 years. Upwards of 10 states have adopted it. And as I said, it's a very simple principle, which is if you take an oath of office to vote the way the voters tell you to vote, you have to live up to that oath, and if you don't, you'll be replaced.
Thank you, Delegate. Is there anyone in opposition to this bill? Not seeing any. Is there a motion? We have a question. Senator Sturdivant.
Thank you, Mr. Chairman. And my question is, because I understand I've read the DLS description, which was limited to the faithful elector, faithless elector piece. It does rewrite the entire code on the selection of electors. So that is my question is, why are we, do we need to rewrite all the code on that area just to address this one specific issue?
Mr. Chair, thank you, Senator, for the question. I'm going to defer to counsel on this, but I think the big picture answer is that while there are a lot of new words on the page, they capture existing Virginia law on how electors are elected, how the presidential elections are conducted in Virginia.
Is that counsel you want to address that? Thank you.
Mr. Chair, Senator, so the bill reorganizes sections of the code that deal with electors that are in disparate chapters and consolidates them under one chapter. And then in doing that, it makes a number of technical amendments. So right now, for instance, in the code, there's some ambiguity when the code talks about electors. Sometimes it means people who have been elected to be electors, and sometimes it means people who have been nominated to be electors. So that's clarified in this bill as a technical amendment, since we're bringing it all together under one title. But there are no substantive changes. So in terms of, for instance, the number of petitions that need to get gathered or the dates that things happen on, all that is the same. and except for the additions that the delegate pointed out with regard to faithless electors.
Thank you. Thank you.
Mr. Chair, I have a motion at the appropriate time.
Then now is the appropriate time.
I would move to report this bill.
So motion, is there a second?
Second.
Please open the vote.
Ayes 14, no zero, one abstention.
Thank you, Delegate.
Thank you, Mr. Chair, members of the committee.
All right, next, I've seen some members waiting. We will go back to Delegate Sickles, then Delegate Reed, then Delegate Anthony, then Delegate Shen.
Delegate Quinn's here.
And O'Quinn finally decided to bless us with his presence.
We'll bring your bill back for that.
Thank you, Mr. Chairman.
You have the floor,
Should I
sir.
proceed? Okay. I have this bill 1534.
1534.
It has to do with challenges, various challenges that take place during the electoral process. I think parts of this bill might be part of a bill that the Senate has passed already, but maybe not all of it. Maybe council could explain that, Mr. Chairman, if that's possible.
Yes, just present your bill
Okay.
first, and then we'll have council explain any difference.
Well,
or any.
it does three things. It eliminates in-person voter challenges at polling places. So you can't stand outside the poll and say, this person's not eligible, this person's not eligible. Second, three voters can challenge somebody's eligibility or voter registration, but they must do so in circuit court for that locality. That's the second thing it does. And if you want to challenge the registrar's decision to approve you on the ballot, you have to do that at least 60 days before the primary or general election. We had a situation in my county where we had a school board candidate who the registrar put on the, she had done everything she was supposed to do. She's on the ballot, and the registrar challenged it, not what she had done wrong, but she challenged what the registrar had done wrong and tried to get her stripped off the ballot. This would prevent that from happening because you'd have to do it 60 days before the election.
Thank you, sir. Is there anyone in opposition of this bill? So if we have one online, we'll take that after we take in-person testimony. Please come up, please. You have 1 minute.
Clever Wheeler, Albemarle County Electoral Board, speaking for myself. I want everyone to understand, I know you do because you're on P&E, but to restate, to challenge a voter's right to vote on Election Day in a polling place or in the 45 days, it must take place inside the polling place. The challenger must sign a sworn document. The person being challenged must sign the document, and the officer of election who is witnessing it must sign the document that says, for whatever reason, the challenger thinks that particular person should not be allowed to vote. The challenged voter gets a ballot, and it's put in the machine, and it counts. But that sworn document then is taken to court. Thus, the person doing the challenge better be absolutely 100% sure that they're right in challenging somebody, but it doesn't take place outside. Thank you.
Thank you. We have one person online. You have 30 seconds, and please make sure your camera is on.
Thank you, Chairman and members of the committee. My name is Lindsay Zaya. I'm with Virginia Institute Action, and we oppose HB 1534. My understanding of this bill is that it would change some of the oversight from what the current registrars have oversight over and switches that over to some of the court's oversight. And we believe that registrars are really the best people to conduct this part of the process since they are responsible for keeping accurate and current voter rolls. And so we just think that they're best positioned to oversee this process. Thank you.
Thank you. Do we have members and people here in support of the bill? Please stand up so I can put an accurate number of time on the clock. You have 2 minutes.
Mr. Chair, members of the committee, Tram Win with New Virginia Majority. We strongly support this bill. Some of the provisions that are in the bill are in Senator Van Valkenburg's SB 196 around voter registration challenges to make them have those challenges in the circuit court. And the addition is the candidate challenge. In-person voter challenges on election day can cause backups on election day. And so we want to make sure that any voter registration challenge happens before the election to clear up all of that confusion versus doing it in person.
Thank you.
Good afternoon. I'm Jane Newell, speaking for the League of Women Voters of Virginia today. The League is very much in favor of this bill. The bill would dispense with a relic of Virginia's past. We have a modern voter registration system with professionals making decisions as to who is eligible to vote. Challenges are still possible before a court as appropriate, and the bill would also prevent challenges to candidates in the middle of an election where all the facts have been available since well before voters began casting their ballots. Such challenges may be specious and are disruptive of the electoral process, not to mention unfair to candidates. Thank you.
Thank you. Do we have anyone online in support?
No.
You have 30 seconds. Please make sure your camera's on.
Ty Mallory, you can begin your testimony.
I'm Ty Mallory with the Virginia NAACP. We support the bill.
Thank you.
Mr. Chair.
Just 1 second. Is that all? Okay. Members, comments from members of the committee? Yes. Senator Van Valkenburg.
I motion to report this fine bill.
Second.
Mr. Motion has a second before us. Please open the vote.
Ayes 8, no 7.
Thank you, sir.
Thank you, Mr. Chairman.
Next, we'll have Senator Reed, HB 26. Delegate Reed, forgive me.
Thank you, Mr. Chair and members of the committee. So before you is House Bill 26, and in this particular part of the code, what we do is we identify what is an acceptable ID for the purposes of voting. And what I'm doing in the very last section here, Roman numeral 6, is to add that any photographic ID that has been issued by one of these organizations, which are the ones who certify and license senior living facilities, nursing homes, and those other types of facilities along those lines, that would also count as an acceptable ID. The intent behind this is that when we have large senior communities or nursing homes, there are individuals who will no longer drive. They have no reason to go to DMV to get a non-driving permit, and this would allow them to use their community-based ID for the purposes of voting. That's the gist of the bill, Senator.
Thank you, Delegate. Is there anyone in opposition of the bill in the room? Is there anyone in opposition online?
Yep,
Is it? All right, please come up, ma'am. You have 1 minute.
Clever Wheeler, Albemarle County Electoral Board, speaking for myself. Registering a person to vote is very serious. We've talked about it. The registrars do it. Creating an ID for that person is equally serious. All people who use Medicare or Medicaid must have a photo ID. If they go into a doctor's office or an emergency room, they need to have a photo ID. So if they're living in a retirement community, they have to have an ID already. There is no backup for the people who create a photo ID in a nursing home or an adult senior care facility that would warrant them being able to authorize someone to vote, because presumably this ID would be just for the purpose of voting. Thank you.
Thank you. Is there one person online in support or in opposition? Opposition. 30 seconds, please. Is that the same member that's been? Okay, 30 seconds, please.
Thank you very much, Chairman. My name is Lizaya. I'm with Virginia Institute Action. We opposed HB 26 because currently a voter ID is not required to vote in Virginia. If you use the affirmation statement then you're not required to provide an ID. And so because of this reason, we feel like adding to the list of approved IDs is redundant at this point and would reconsider the need to add additional IDs under the circumstances if there was no affirmation statement. Thank you.
Thank you. Any members here in support of the bill? All right. Please, you have 1 minute to come up. I also see comments from members of the committee. You will have a chance to speak to the bill after this.
The League supports this bill. The bill adopts an additional form of ID, and specifically this bill recognizes that voters have IDs issued by private entities, but private entities that are licensed or certified by Virginia agencies. Like our DMV, photo IDs from these private entities, by being licensed or certified by Virginia, can provide the same assurance that the voter is registered.
Thank you. Now we have Senator Durant is in the queue.
Thank you, Mr. Chair. Question for the patron.
You have the floor.
Thank you, Mr. Chair. Hello, good afternoon. I was just wondering, what's the genesis of this bill? Did this come at a request, or was this a challenge that was being posed by, I think you understand the point I'm going with this?
Yeah, Mr. Chair, if I might respond. So the genesis behind this is that there are a large number of senior communities, senior living communities in the district that I represent, and also across, I think, Northern Virginia and other areas, where, again, they are self-contained communities where those individuals really don't drive anymore. They don't have a need to go to DMV. And I think one of the things to point out here is that this is actually a community ID that is used for accessing secure buildings. It's used for accessing other facilities within the community. So this is not just a source of voter ID. So this was, and quite honestly, there's a community that I represent that I want to say is about 2,000 individuals, and they have their own voting precinct in that particular location.
Thank you. Senator Van Valkenburg, then I'll entertain a motion.
Mr. Chair, may I just briefly ask a question of the patron first, and then I'll have a motion?
Yes, you have the floor.
Mr. Chair, I would ask Delegate Reed if it's the fact that it's already law that if a voter uses an ID that was gotten by any employer that they are employed by, they could use that ID to vote already.
Mr. Chair, that is correct. That's actually in line, that's in line 27, Roman numeral 5.
So, Mr. Chair, noting that I think that an agency, a group home, or a home that has that is already sponsored by a government agency is probably more secure than any business in the Commonwealth that employs somebody, I would move that we report this bill.
Second.
So, motion and a second. Seeing no further comments, someone in the queue, please open the vote.
Ayes 10, noes 5.
Thank you, Mr. Chair. Thank you, members of the committee.
Thank you, Mr. Chairman. The HB 998 is basically a technical amendment for organizational purposes approved by the Voter Registrars Association of Virginia, including the County of Fairfax.
Is your friend. Is there
Absolutely.
A motion? Is there a motion to report?
No. What's the do?
Any comments from committee? There's a motion. There's a second. Please open the vote.
Ayes 12, noes 3.
Thank you.
Thank you.
Next we have, we go back to the uncontested, kind of like delicate Tran. She's been waiting here for a while. And you have HB 989.
I do have, yeah, House Bill 989. And I appreciate your the opportunity to talk about this bill. It requires the Department of Election to provide certain election-related information on the department's website. It also requires the Department of Elections to translate this information into languages that are covered by the Virginia Voting Rights Act, and to check the translations before every primary and secondary election. There are only currently 2 languages that are covered by the Virginia Voting Rights Act, that's Spanish and Vietnamese, and the Department of Elections voluntarily translates materials into these 2 languages as well as Korean. So what we're doing here is to address a gap in the code in terms of identifying information that should be provided on our website at the state level, and also to carry forward the good work that's been taking place in this administration and past administrations into forward future ones as well. I welcome your questions.
Thank you. Is there anyone here in opposition of the bill? Is there anyone here online in opposition of the bill? Is there anyone here in support of the bill?
Mr. Chair, I move to report and refer to finance.
Second. Well, he's in support, so it's okay. There's a motion to report and refer to finance. Please open the vote.
Ayes 15, no 0.
Thank you so much.
Next, we have Delegate O'Quinn, and we will hear HB 742 first, and that was uncontested in the House. Is that correct?
Yes, sir, Mr. Chairman.
You have the floor, sir.
Thank you. I apologize for being late. I think I was in the same committee as Senator or Delegate Sullivan and Delegate Shin. Nevertheless, House Bill 742 is a bill that I've been working on that depoliticizes the process for selecting the elections commissioner. The original bill that I put in sort of went about it one way on a certain timeline, and in working with the chair of House P&E, we sort of reworked that timeline a little bit because the timeline's a little more complicated than we had originally thought, with the timing of the gubernatorial election and then the subsequent appointment of the electoral board members or the State Board of Elections members. So essentially what this does is shifts the power of appointing the elections commissioner away from the governor and gives it to the State Board of Elections. This bill would keep the five-member board with the 3-2 split in favor of the governor's party. But what we've done is adjust the commissioner's appointment timing so that instead of the appointment being made in the first year, it would be made by the state board in the governor's second year after the 2025 elections. So by then, what we're looking at that point is that the governor could make 3 of the 5 appointments that are staggered and would be coming up. The governor would then have the 3-2 split in favor of their party. And that's, of course, how it's always been done and how I would still envision that. So what the fail-safe here is that if the Board of Elections does not get to a consensus choice, which would take 4 or 5 members to get there, then it would be deemed that the current commissioner would be reappointed. It's not as big a deal as it sounds because it comes through on the appointments resolution, and certainly we could pull that off if there's a consensus pick to get there. So essentially what it does, though, is it gives the board all the incentive in the world to get to a consensus pick with the 27 legislative elections coming and the 28 presidential election coming soon after that. So this was our sort of collaborative effort to get to a timeline that actually works. And I think you all know the gist of what we're trying to get at with this bill.
Thank you, Delegate O'Quinn. Is there anyone in opposition of the bill in the room? Is there anyone in opposition online? All right. Is there anyone in support in the room? Please come up, sir. You all, please all come up. You have 2 minutes.
Mr. Chairman, David Bailey on behalf of the Voter Registrars Association of Virginia. Those of you who've been around a few years longer know that there have been various renditions of this bill. We know that one time a bill passed and went to the governor, and the governor vetoed it because the governor didn't want to give up the appointment power. We would really commend this bill to you. The Voter Registrars Association fully supports it. If you should happen to see some small change that the patron's willing to make and you all wanted to make, but please try to keep this bill alive. It has a real good possibility of making a change and making the elections department much more free from political influence than it is right now. Thank you.
Mr. Chairman, I'm Susan Beals, the current Commissioner of Elections, and I support this bill and its passage, as well as the previous commissioner.
Can I ask a question, Mr. Chair?
You have the floor, sir. Senator Deeds.
Ms. Beal, do you feel political pressure because of your appointment by the governor?
I think that it would be wise to have the Board of Elections that is made up of former legislators, former P&E members, former candidates, and former electoral board members have a say in the choice of the commissioner. Thank you.
Yeah, Mr. Chair, that wasn't directly responsive to the question I asked. Do you feel political pressure? I mean,
Right now, I'm appointed by the governor. He is my boss.
okay. And Mr. Chair,
Senator Deeds.
you think we can remove politics, partisan politics from elections like this?
I believe this will be a step forward.
Okay, and this is similar to what I guess Senator Vogel had several times in the past. Is that right? Or
This is actually a better version that has been worked out between
Okay.
both sides on the House side.
okay, thank you, ma'am.
We got one more member to speak in support, and then we'll have further comment from the committee. Or
In the
question.
interest of time, I just wanted to tell you the league actually supports this bill.
Thank you. Thank you so much. Anyone online to support? All right. So comments from the committee, and Senator Van Valkenburg, you are up in the queue.
Thank you, Mr. Chair. I have a question for the patron.
The floor is yours, sir.
Thank you. I've been very skeptical of these bills in the past because I've been on P&E for 7 years now. I know how partisan election law is. And so I guess if you're looking at lines 144 to 146 of the bill, and it says, if the board fails to appoint a commissioner or fails to communicate an appointment of a commissioner to the General Assembly by June 30th of such year, the commissioner serving on such date shall be deemed to be reappointed. And that seems like a real pivot point, because if the board gridlocks partisan-wise and it's 3-2, and they can't appoint somebody, isn't there an incentive if you're in, let's say, I mean, right now we have a Republican governor. What if the next governor is a Democrat, but the board is temporarily a Republican majority board and the term is up? There's a lot of, I don't see how that doesn't take, that seems like a different version of politics and a different version of gridlock, if you see what I'm saying. Like, I'm not sure, I mean, what happens in that scenario? We just hold on to the old person who, do you know what I'm saying? Do you see what I'm getting at?
I do understand what you're getting at, Mr. Chairman. I would say that the fact that we have the 25 gubernatorial election, the governor then gets to make their electoral board members, so that then the electoral board is the Board of Elections is majority of the governor's party. So that corrects the split that you're talking about. So you've got your 5 members. There, in your scenario, you would have 3 Democrats, 2 Republicans. So then you get over that hump, and then when they pick the commissioner in the next cycle, then let's say your scenario plays out and they don't actually get to a consensus pick, then that name would go on to an appointments resolution, which would originate in the Senate. If there's a consensus pick that's made before we get back to session, then we would just remove that name from the resolution, and the Board of Elections would make their appointment. In the event that there's a straight up deadlock, and the name comes off the resolution and we're still left, the fail-safe here is that the director of operations would then become the acting commissioner until such time as they could get to an appointment. So we could either keep the name that's on there, you could pull that name off, and the director would then become the acting commissioner in the interim.
Senator Van Valkenburg.
Why should we believe that the group that's in the minority is going to have one person that's going to step out? I mean, if it's a 4-1 vote to elect a commissioner, I mean, that one person in the world we're living in now could face a lot of pressure, politically and otherwise. I mean, I feel like I read a news story every day about election officials being threatened by violence. Why should we think somebody in the minority party is going to be willing to step out?
Mr. Chairman, I would say that in times past, I would say in most times past, that the Board of Elections has tended to work together for the greater good. Again, it's just as Under your scenario, it's the same issue to remove the commissioner. It takes 4 out of 5. So if the board puts forth, as a whole, puts forth a name of someone who fits the bill of what an election commissioner should look like, I don't think it's far-fetched to think that you could have a 5-0 vote for an elections commissioner.
Thank you, sir. For now. Thank you, Senator. Any more comments from members of the committee? I see none. I entertain a motion.
Mr. Chair, I'm going to move to pass by indefinitely if we're making a motion.
It's a motion to PBI, and there's a second. Please open the vote.
Ayes 7, noes 8.
Mr. Chairman. Mr. Chairman.
The bill is before us.
Yep.
That was the primary, so now we have.
That was second substitute.
No, it wasn't substitute. That was a primary. Now the motion before us. Before we get to a motion, Senator Rome.
Thank you, Mr. Chairman. Mr. Chairman, could this bill go by for the week?
Bill goes by for the week. All right. Bill goes by for the week. All right. Thank you, sir. Thank you, Delegate.
He's got another bill, I think, doesn't he?
No, that bill should have. 682 should have gone to. That was a mistake. Okay. Delegate, please forgive me for pronouncing your name incorrectly. I'm sorry?
Srinivasan.
Srinivasan. Yes, sir. Thank you. You have House Bill 1408 in front of you, sir.
Thank you. Thank you, Mr. Chairman and members of the committee. HB 1408 directs the Department of Elections to work with the localities to develop standards for the minimum number of voter satellite locations a county or city shall provide to their general election in the 14 or 30 days period leading up to the election. In doing so, the Department of Elections shall consider the total registered voter population, population density, and proximity to develop the standard. The goal of this legislation is not to be overly prescriptive by applying a one-size-fits-all formula, but rather direct the department to develop standards based on each locality's individual needs. I would ask the committee to support the measure, and I'll be happy to answer any questions you may have.
Thank you, Delegate. Is there anyone in opposition of the bill? Is there anyone online? Please make sure your camera is on. You have 30 seconds.
Thank you, committee. My name is Lindsay Zaya. I'm with Virginia Institute Action. My understanding of the bill is that this would be a requirement. So if I misunderstood that, my apologies for localities, but we just believe the local election administrators are best positioned to make these choices. They understand the relevant details about choosing the number of early voting locations for their locality, and I believe that they'd be best positioned to determine the number of early voting locations. Thank you.
Thank you. Do we have any members here in support of the bill? And please simply state if you support the bill or not. Thank you.
Mr. Chair, members of the committee, Tram Win with New Virginia Majority. We support the bill. I think it's an elegant solution in terms of creating standards and guidelines for how many voter satellite offices, but it doesn't actually create a mandate. So it just provides uniformity in terms of standards and guidelines for every locality. Thank you.
Thank you.
The League of Women Voters supports this bill. Standards exist for many aspects of elections, and the number and distribution of satellite voting locations should be no exception. Standards can be very detailed descriptions of various scenarios and how the numbers and locations of satellites should be determined in each. And as previously said, it is a guideline or a standard, not a requirement.
Thank you. Any comments from the committee?
Yeah, Mr. Chairman.
Senator Evans.
Thank you. What would happen, Delegate, if they had standards or guidelines and they were not met? Would that be the basis for a challenge of polling places, or are these completely voluntary? This is something I met with the commissioner. This is where the Department of Elections would work with the local Board of Elections. This is where we said, this is a guidance. The commissioner felt that they would work with the local board to make sure that this is not something that, that would be a hindrance to them. And they will take their feedback in developing it.
Thank you.
Senator Durant.
Mr. Chair, a question for the patron. I think speaking to the bill, the way I'm reading this language, it seems pretty prescriptive, not permissive. I mean, there's some guidelines here that they have to include a recommended minimum of of offices with that 14-day window as well as that 30-day period. So there could be some recommendations that would come outside the scope of the language of this bill, the way that I'm reading it.
Mr. Chairman, I would say, Senator, the intent of this was to develop the standards and to work with the local board of elections. The intent was not to give a particular number, but to develop a standard. That way we take into account the population density and the local, registered voters population.
Follow-up question, Mr. Chair.
Senator Durant.
But again, going back to that original point, and I think we've already said this earlier, is that there could be some recommendations that's appropriate for that particular locality that would fall outside the scope of what these recommendations that are required by your bill to be developed. I think that's kind of the crux of the concern, is that falling outside the scope of what's could be particularly appropriate for what that locality deems appropriate.
But Senator Durant, I would say, if council could correct, if that falls outside the scope, it's only recommendations. It's not necessarily mandated.
Yes, Mr. Chair, that's correct. My question is it possible that there could be some recommendations, or do those recommendations have to fall within the framework of this?
But I guess, council, if you want to try and answer that.
Yeah, Mr. Chair, Senator, so the bill would require the Department of Elections to develop these standards, but it wouldn't usurp the authority of localities to determine the number of satellite offices. So while they would have to they would have these guidelines to use, the bill doesn't require that they use them.
Thank you very much, Mr. Chair. Thank you, Council.
Now is the appropriate time to entertain a motion, if there is one.
Move to report.
Second.
There's a motion, there's a second. Please open the vote.
Ayes 8, no 7.
Thank you, sir.
Thank you. Thank you, Mr. Chairman. Committee.
Absolutely. Delegate Shin, I know you're here. You have 4 bills, so I'm going to save the best for last. And so we're going to have Delegate Simon, House Bill 6265.
Thank you, Mr. Chair, members of the committee. This is one bill, so hopefully it'll go quickly. Mr. Chair, members of the committee, this bill has to do with recall elections, and what it does is it really does 3 things. The first thing it says is if you're going to collect signatures for a recall petition, you can do that, but you've got 90 days between the date you start collecting your first petition and the day you get your last. So you can't start a petition recall the day someone's elected and spend 4 years collecting signatures hoping you get to the right number. The second thing it does is it says you can't bring the same recall petition for the same conduct over and over and over again. So you get sort of one shot at that. And if you're found that you haven't proven your case, you can't just go collect another set of signatures and try it again as a way to sort of harass the elected official. The third thing it does is it talks about how we deal with conflicts of interest. So if the person being recalled is the Commonwealth's attorney, it establishes a process for how we find somebody else to prosecute that case, because the Commonwealth's attorney is not going to prosecute the case against themselves. And then the fourth thing it does is it says you can't have any discovery pursuant to a trial on this. So in other words, this is the petition process isn't supposed to go get you in front of court so you can find out if there's been misconduct. You've got to have misconduct first, then do the recall, and so make sure that everything goes in the right order. It's been a problem in a number of Northern Virginia localities with school board members and folks where their dereliction of duty was essentially a political disagreement, and then they spent their entire 4-year term sort of being constantly recalled, having to pay attorney's fees and so forth. So that's what this bill aims to solve.
Thank you, Delegate. Is there anyone in opposition of the bill?
Mr. Chairman, can I ask a question?
Just one moment. Is there anyone online? Okay, please make sure your camera is on. You have 30 seconds, and then we'll take comments from members of the committee.
Hello, my name is April Breslau. I'm here to speak in favor of the bill. Is it appropriate to do that?
No, we're just taking opposition right now. But since you're the only one online in support of the bill, we can take your testimony now.
Okay, thank you very much. My camera is open, but I'm not sure that I'm showing. Let me try one other thing. I apologize. There we go. I apologize. My name is April Breslau. I live in Alexandria, but I'm speaking today on behalf of the Virginia Grassroots Coalition. We're an alliance of 55 grassroots groups representing about 15,000 voters across the state of Virginia. The coalition supports HB 265. Under current Virginia law, local officials have been forced to contend with open-ended removal proceedings that are costly, time-consuming, and can go on for their whole term. The improvements that Delegate Simon has mentioned will make the process more fair and less susceptible to misuse.
All right, ma'am.
Thank you.
Thank you. Anyone here in support of the bill in person? All right, comments from members of the committee, Senator Perry, and then Senator Diggs.
Thank you, Mr. Chairman. And I'll tell the patron, I understand the intent, and I've seen these, I've seen the concerns I think that you're attempting to address with this bill. I just have a couple of questions. It looks like, and I've never been a party to one of these petitions, so I've never really had to deal with them, but it looks like the code lays out in 24.2233, subsection A1, it lays out various reasons, right, that you could say someone should be, you should file a petition for removal. And those reasons, and some of them look relatively vague, right? Things like, quote, misuse of office, or, quote, incompetence in the performance of their duties, right? And that's a little bit subjective. So my question for you is really, whenever you say things like, the removal grounds, you can't have a petition where the removal grounds are the same language, but based on different conduct. I guess my question is, some of those things could be cumulative, right? To show misuse of office, to show, that misuse of office or incompetence in the performance of their duties, right? Like maybe with the first 5 things you laid out, it wasn't enough for incompetence, but after 10 you have. And so I guess my question is, I don't know that I think your bill says that's not enough, right? And so I guess, are there freebies on incompetence? That may not be sufficient. You can have a certain amount of incompetence every 90 days. You can have incompetence, and that's fine. We'll forget it for the next 90, or how does that work with your bill?
So the way that works is that you go to the court and say, essentially, these folks are derelict in their duty because they won't open the schools. And I really feel like the schools should be open, and they're derelict in not opening the schools, letting my kids go there. And 90 days later, they still haven't opened it, and 90 days later, they still haven't opened it. You can't bring that same cause of action over and over and over again over what is essentially a political disagreement. And so if you would have different, I think the other answer is you'd have different conduct, right? So the first one may be a freebie, as you state the question, but then you have different conduct you'd have to explain in your petition in your second petition. So the fact that they didn't badge into work, say a commissioner of the revenue, right, didn't badge into work for 30 out of the first 90 days they were in office. They took a month-long vacation to the Bahamas, and then they did. You go, and the court says that's not really sufficient. You would have to, and they did it again, 90 days later, that would be a different set of conduct. It would be another period of time where they didn't badge in. And so I think that would be sufficient for a second petition, because it would be different conduct.
Senator Perry.
So if I filed a petition, right, saying, hey, you, Mr. Treasurer, you are not showing up to work, right? Exactly the example you gave, right? And I file a petition and I'm like, that's a misuse of your office. You're supposed to be there. You're accountable to the taxpayers that elected you to represent them, right? And, that's dismissed. Like, no, he's only 90 days into his office. This is too soon, right? When I go back and file a second petition because that behavior continues, does that mean I can't include the information from the first petition saying, no, court, this is a long now ongoing standing pattern of behavior because I included it once, so now I'm precluded from including it again?
Mr. Chairman, I would answer the delegate that...
I'm a senator.
I'm sorry. I apologize. I would answer the senator. She's got me a little flustered, but I'm going to persist. The grounds of reason stated would have been the basis for a previously filed petition. I think you could do cumulative. I would say that your initial piece wouldn't be precluded. I think these are different grounds. This is now a pattern, where it was one time an incident has now become a pattern. I think those would be different grounds, and I would argue that those would be admissible.
If I could chime in for a moment, and I know you two, you're a lawyer, correct?
Yes.
Yes, so I don't want to get between two lawyers speaking. But my understanding is if you file for petition, you get your signatures in 90 days, that still has to go towards a court to validate whether or not they would uphold that removal of office, so to speak.
Yeah, Mr. Chairman, I would say that, right, the court would have discretion to say whether that was in fact new or not, and it would be, again, you still have a court process that would determine the validity of it,
right.
And they'd have to interpret this statute, not Senator Perry or I.
Mr. Chair.
Senator Van Valkenburg.
Would Delegate Simon just consider a friendly amendment that maybe tightens that language? From council, maybe you can figure out a way. I hear what Delegate Perry is saying, right, which is it's like the double jeopardy thing, right? Is that what did I say? Oh, sorry, I was talking to him. Sorry. So I hear what Senator Perry is saying, right, which is it's kind of like the double jeopardy thing, right? You do break and entering, right, and then you're found not guilty. You can't be charged with that breaking and entering again. But if you break and entering another house, right, you can be charged with that, and clarifying that you're being charged with a separate thing specifically, right? So if council could.
But just a moment before we start amending, the point is a court will still deem whether or not a petition to remove someone from office had merit or not. So even though you could file a petition and then 90 days go to court, it doesn't get held up and the same behavior continues, you can go back, get petitions in 90 days, go back to court, and the court can say, yeah, well, they showed it this time. That's how I understand the bill.
Mr. Chairman.
If you like to offer an amendment for council to tighten up this legislation, and if it's so fit for the delegate to see it as a friendly amendment, we certainly entertain it. I don't know if council could do that on the spot here.
Mr. Chairman, Senators, we could add on line 56, shall not be certified when the specific grounds or reasons stated, so that it's not general grounds, like it's not, the general misuse of office, but the specific didn't badge in, et cetera. And then, again, deal with the cumulative question, I'm not sure.
Mr. Chairman, if this bill could just go by for the day, I'm happy to talk to the patron about it. Like I said, I'm supportive of what he's trying to do with the bill, but I think the language of the bill and the courts are bound by the language. And if I'm a judge sitting, I'm going to say I can't consider the previous conduct. I can't. The bill prohibits me. The statute prohibits me from doing that. Mm-hmm. And so I understand the chairman's point, right? But I think this limits the court's discretion, and I think the court is bound by the language that we include in our statutes. And it sounds like from Delegate Simon, from his perspective, that's not actually what he's intending.
All right, thank you. Delegate.
Happy to work with Senator Perry on this one.
All right, just one moment. We did have Senator Diggs in the queue. We maybe have a question as well. We may want to take a look at when this goes by.
Thank you, Mr. Chair. Question either for the patron or for council. I'm not a lawyer, so I don't know that I understand discovery as it applies to this. So as I understand it, no discovery shall be allowed. Does that mean that me as the person being recalled do not have the ability to ask the petitioners what their specific allegations are, or do they have to stand on just what they put in the petition that may be very broad? Or counter to that, I would think certainly me as the person being recalled would not be subject to discovery to help the petitioners make their case. So does that cut both ways, or what is the intent there?
Mr. Chairman, I'd say the Senator cuts both ways. And the idea, again, is that you're not supposed to use the statute as a fishing expedition, right? So in civil practice, for instance, you might file a suit, you make an allegation. You may not know if you have enough evidence or not. That's part of what the discovery process is all about. And so then you find out what the evidence is. And this says, no, you got to put the evidence first. You got to gather your evidence, put your evidence up front, then file your petition. You can't use the petition as your hook in there to try and find out. So you can't say, for instance, using the example that we've been beating up on the treasurers about, but the treasurer, I don't think they've been coming to work. I've heard a rumor that they don't show up a lot. So I'm going to file this recall petition. I'm going to go to court, and then I'm going to subpoena the badge records, right? And then find out, well, they've been there the whole time. And meanwhile, the elected officials got to hire attorneys, defend themselves, and go through this whole process on really no basis at all. So that's what that language is trying to get at. And it does cut both ways, so there won't be discovery. And again, sometimes the discovery, again, it can be a very expensive, time-consuming, lawyer-intensive, at hourly rates process. And so it can be abused as a way of harassing elected officials, and that's what we're trying to get at with that line.
Thank you.
Mr. Chairman, if I could.
That bill will go by for today.
I was just going to say, to answer Senator Dick's questions, you could file a bill of particulars, right, which is not part of the discovery process, to have them lay out what it is that they're actually alleging, the specific allegations.
All right, thank you. That bill will go by for the week. Thank you.
Thank you, thank you, Senator Ross. Thank you, members of the committee.
Delegate Shen.
Thank you, Mr. Chair. Did you have a preference in which order?
Yes, House Bill 943. First, we'll start with the uncontested.
943, okay. Well, that one, Mr. Chair and members, is a bill that is designed to just extend protection to local electoral board members, general registrars, and deputy registrars, employees in their offices, and officers of election by making them I'll bring the mic down. Everywhere I go, I'm always on my tippy toes. It just allows them to be eligible to apply to be on the protected voter list.
Thank you. It's a simple bill before us. Anyone in opposition? All right. Is there a motion? Is there a motion? Second, please open the vote.
Ayes 15-0.
Thank you, sir. Delegate Shen, House Bill 939.
Okay. Thank you, Mr. Chair and members. House Bill 939 seeks to extend the prohibition of a firearm from 40 feet of a polling place to 100 feet of a polling place. Last November in Spotsylvania, we saw reports of an armed security officer who had been hired by a local candidate to just patrol the polling place. They were there for no other specific duty except to wear a firearm on their person and just walk around the polling place. And so we hope that by extending this 40-foot line to 100 feet, we voter registration sites, voter satellite offices, central absentee voter precincts, and election certification meeting sites for the State Board of Elections, we can ensure that voters will feel safe when they go to cast their ballots, and also for election administrators to feel safe in their workplace as well. The mere presence of a firearm at a polling location can be really intimidating to voters who come to make their voices heard and participate in our democracy. We did make an amendment in the House to ensure that we were not penalizing someone who happens to be in the 100-foot vicinity, unknowingly veering into that within that boundary. So we did make that amendment in the House.
Thank you. Is there anyone in opposition of the bill? You have one in person. You have one in person, two online. Please place a minute on the clock.
Albemarle County Electoral Board, speaking for myself. 100 feet is not very far. However, there are many polling places in strip malls. There are many polling places that have limited parking. And so if someone comes in from hunting, November elections, middle of hunting season, and they come out of the hunting field and they've got their guns with them and they're in their cars, where are they going to park? They've got no place to park. So you're going to disenfranchise people who are trying to feed their families during hunting season. There are many places, again, where there is no parking greater than 100 feet beyond a polling place. And those people will not be able to come and vote because there will be no place for them to park. Thank you.
Thank you. We have two online. Please make sure your camera is on. You have 30 seconds apiece.
Allison Anderman, you can begin your testimony.
Good afternoon, Mr. Chairman and members of the committee. My name is Allison Anderman. I am an attorney and gun policy expert consultant with Brennan Center for Justice, a democracy-focused organization, and Giffords Law Center to prevent gun violence. On behalf of both organizations, I offer our enthusiastic support of this bill. The Supreme Court has explicitly stated in the Heller and Bruin decisions that polling places are sensitive places where it is presumptively lawful to prohibit guns. By analogy, other places where elections are being conducted and votes are counted.
Ma'am, thank you. Thank you for your testimony. Is there anyone in opposition of the bill online? Are they in opposition?
April Breslaw.
She's in support.
I'm actually, right,
Okay.
I'm actually here to support.
All right. You have 30 seconds, ma'am.
Thank you. As mentioned, I'm April Breslaw. I'm from Alexandria, Virginia. I'm speaking today on behalf of the Virginia Grassroots Coalition. The coalition does support HB 939. We do view it as an election safety bill that will prevent voter intimidation, promote voter and volunteer safety, and foster election integrity. So we thank you for sponsoring or supporting this common sense legislation. Thank you.
Thank you. Members in person in support. Let's see, please. You all have 3 minutes for the group. So please, if you take up all the time, then the members in the back of the line won't have a opportunity to speak.
Yes, sir. Thank you, Mr. Chairman, members of the committee. My name is Lori Haas. We wholeheartedly support this bill. When firearms are used to intimidate and chill free speech in the execution of our, protected rights, such as voting, there's something wrong in this Commonwealth. 30 feet is not enough, as described by the delegate. 100 feet is not too much. If you can't park within 100 feet, maybe you can park within 150 feet. If you can't park and you can't go to exercise your voting rights without your firearm, you can vote absentee. We have all sorts of accommodations. Firearms have no place within 100 feet of a polling place, intimidating people exercising their right to vote. I hope you'll support the bill. Thank you.
Mr. Chairman, Andrew Goddard, Virginia Centre for Public Safety. My organisation supports the bill, and I'm speaking personally as an inside poll watcher for the last 15 years. I strongly support the bill. Thank you.
Thank you, sir.
The League of Women Voters strongly supported the General Assembly's decision to restrict firearms at the polling locations. This bill would just logically extend that existing law to all locations where ballots are processed and counted. We're clarifying that it only prohibits carrying firearms on the person, not left in the car. Thank you.
Good afternoon, Monica Hutchinson, President for Henrico County NAACP, and on behalf of the Virginia State Conference, we support this bill. Thank you.
Thank you. We have comments from the committee. Senator Sturdivant.
Just a question on the bill for the patron. As I read it, the question that I keep coming back to is whether or, I've got polling places in my district that are within 100 feet of the roadway. And whether or not, if somebody gets pulled over driving past a polling place that's less than 100 feet from the roadway, I understand there's a part in here about occupying your own private property. That sounds more like, to me, like it's talking about a home as opposed to a vehicle. Maybe that's meant to cover the vehicle piece of it, but that does give me some pause. But I also wonder, what if you're driving someone else's car and you get pulled over, you have a firearm with you on you, and I know that's an unintended consequence, but I think that is a potential negative unintended consequence of this.
Mr. Chairman, I would say that part of the clarification in the amendment that came out of the House, which was about knowingly carry on or about his person a firearm, and I think that was the intent, to carve out the piece about someone unknowingly veering into that 100 feet space, be by being pulled over or because they were driving past that 100 feet. But I would ask council if maybe the council could clarify for us, because the intent of the bill is not to bring that person in, right, who's driving by and happens to be pulled over or something like that.
Let's see the amendments here.
Mr. Chair, Senator Delegate, I don't know. It might be possible, if someone was driving by, say, 50 feet and you passed by and you had a gun on your person, you knowingly had a gun on your person, does the knowingly apply to the 100 feet of any building, or does the knowingly only apply to the gun on the person? That would be, as it's written, that might be a little ambiguous, so we could clarify that maybe it is knowingly having a gun on your person and being within that 100 feet.
Move the amendment, Mr. Chair.
So The House already moved the amendments, so we don't have to move them. This is the House version. So they already moved the amendments, which is already in the bill.
Mr. Chairman.
Is that correct, Counsel?
Well, I'd have to think of a way to clarify that and still keep the, within the context. But if we want to do that in concept and then try to clarify it for the floor, I could do that.
I feel fine with that. I'd consider that a friendly amendment.
Okay. Move the amendment. Was there a
Second.
motion? A conceptual amendment. All in favor?
Aye.
Move to report.
I have another question.
And we have senators in the queue. We have Senator Perry, and I certainly have Senator McGuire. After that, Senator Perry, you have the floor.
Delegate Shen, thank you for the bill. I just had a question about, I see the carve-outs in, E and D of the various sections about who can who can carry a firearm. You include law enforcement. In light of the events of January 6th, I would just ask about including people like the National Guard. And I don't say that lightly, but they have been called out to places to respond, would likely be carrying firearms to make sure that peace is kept there. And so I just was wondering if there's any thought to including military who are on duty or National Guard who are acting in the course of their responsibilities.
Mr. Chair, I would also consider Senator Perry's amendment or clarification to add this.
I would say,
folks.
As the amendment National Guard that is called out, we have a lot of military men and women who are active duty who, all intents and purposes, could just carry their gun because they're active duty. So if we want to make it more specific, we could say National Guard that is inactivated.
Would there be Mr. Chairman, I would ask Senator Perry, if there would be a way to specifically make sure that we're carving out just National Guard in response, who are acting in response to said event or in the course of said event.
And Mr. Chairman and Delegate Shin, just for clarification, I was looking at this issue the other day. Military and National Guard are two separate things. United States military, the Department of Justice says National Guard is not part of that. So I speak about them separately, but I think that's exactly right. I think the language can be, right, military or National Guard who are responding to an incident or event on the grounds or of the polling location.
Mr. Chair, I'd suggest we just take it back for the week, come up with the amendments, and come up with your amendments, and
we'll hear it next week.
Sure, that's fine.
All right, sounds good. And but Senator McGuire, do you want to speak now, sir? Or do you want to speak? All right, the bill goes by for the week. Next, and you will work with Senator Perry on that amendment, and we have that conceptual amendment in place to ensure that it's within 100 feet and on the person. Next, we have House Bill 940, and we do have an amendment for that we need to move. You want to explain the amendment?
Mr. Chair, I'll read it in. On line 22 of the engrossed bill, after posted, insert comma to the extent practicable, comma.
All right.
I'll move the amendment.
Move the amendment. Second, you want to?
Can I ask a question real quick?
Sure. You want to on the amendment?
Yeah, I guess maybe this is for council or maybe it's for the patron. How is it ever going to be? I guess what's going to make this not practicable?
That's actually so, Mr. Chairman, I would answer the senator and say that this clarification or this amendment came from localities who have previously had polling places in private residence or private properties that have been closed, or the property owners no longer want them to be polling places, and so if they've closed, they're not allowed to go back and post a sign. And so we're really trying to make sure that at least with good faith, the localities are making an effort.
Okay, so we have the motion to move the amendment and second it. All in favor? Aye. All right, the amendment is moved. You want to explain the bill?
Yes, thank you, Mr. Chairman and members. House Bill 940 is a relatively simple bill that is just to ask localities to put in notifications when a polling place has been changed, moved, or closed. This will just ensure that voters who show up on election day or during the early voting period to a polling place that they've always gone to that has maybe moved since, and for them to be able to be notified that that has happened, and they'll be able to figure out where to go next.
Thank you. It's a simple bill. Any comments from the members of the committee? Do you have a motion? Second. All right, please open the vote.
One no.
Ayes 14, noes 1.
He just wants me to talk all this stuff on the floor, that's all. All right, we have House Bill 942 in front of us.
Thank you, Mr. Chair and members. So this bill aims to enhance the accessibility of our election process by prohibiting the placement of polling places and voter satellite offices within police stations or sheriff's offices. It does permit polling places to be in public buildings that share a space with police stations or sheriff's offices when necessary. We think that sometimes the mere presence of police can be intimidating and a tactic of voter suppression, and I'd like to think that this will make sure that folks feel safe when participating in our democracy and going to make their voices heard at the ballot box.
Thank you. Do we have anyone in person in opposition of this bill? Anyone online in opposition? We have 2 online in opposition. They're not, okay. Let's call them up and see. They have 30 seconds.
I haven't either.
She says support.
Ty Mallory, Virginia NAACP, we support the bill.
Thank you.
April Bressel from Alexandria, on behalf of the Virginia Grassroots Coalition, we support the bill.
Questions or concerns, comments from the members of the committee? Okay, have Senator McGuire in the queue first, and then Senator Rome, you're next. Senator McGuire? Okay, must be left over. We'll get rid of that. All right, Senator Rome?
Thank you, Mr. Chair. Question for the patron.
You have the floor.
All right, thank you, Mr. Chairman. Mr. Chair, I would ask the patron, number one, 2 things. So first, do we have a comprehensive list of basically the localities where they are currently using either police or sheriff's department offices to host voting? And then second, if that is a substantial list, if there's like a good number of them, I'm wondering if we should put like a year-long delayed enactment clause on this, for example, because you might have a little bit of trouble trying to find new locations or, to do before July 1st this year.
Mr. Chairman, I would answer the delegate and say I'm not aware of a comprehensive list of all the polling locations that are or are not police stations and solely police stations or law or sheriff's offices. And so I hear the senator's point, and would consider another conversation about it. So maybe we can talk about this over the course of the week when I come back with 939.
So, Mr. Chair, if the delegate wants to pass your bill by for the week, I'm certainly fine with that, because otherwise you're probably looking at getting it continued to 2025.
Sure. I'd be happy to take it by for the week.
That bill will go by for a week.
Great.
Thank you so much,
Thank
Delegate
you,
Shin. And Delegate Ward, last but certainly not least.
Thank you and good afternoon, members of the committee and Mr. Chair. House Bill 1330 is a bill to clarify registered voters. They're legally registered voters, but they have been confined in waiting trial, or if they are confined and they have been convicted of a misdemeanor, that they may vote absentee on an absentee ballot. The reason for this bill came because there had been some confusion. They still do have a right to vote, and there was nothing in the code really that would explain that the purpose for this legislation was to clear it up, that they would still have the right to vote absentee. The purpose of the bill is, again, to expand the voting rights for all registered voters who are confined for specific reasons. Again, they are awaiting trial or it's a misdemeanor conviction, which still allows them the right to vote. And that's the purpose for this bill. These eligible individuals will fill out an online application for absentee ballot. They would receive it and it would be returned. And that's the purpose for this bill.
Thank you, Delegate Ward. Is anyone in opposition of the bill? Anyone online? Or any comments from the members of the committee?
Mr. Chair.
We have Senator Diggs in the queue. You want? Senator Durant, you want to just let me know if you're just in the queue. Senator Diggs, you have the floor.
Thank you, Mr. Chairman. I think your bill is certainly appropriate, and it's only fair. And I just wanted to make a comment that the local jails have been doing this for years, as far as I know. Maybe not every jail, but I know that the several jails that I've been involved with, they always made the opportunity to vote absentee available. So, but thank you for your bill.
Thank you, Senator Diggs. Senator Durant.
Thank you, Mr. Chair. Just a question regarding the bill, and it's helpful to have my colleague next to me share that this is something that, to his knowledge, is being done. Is it already permissive? Are we moving toward a requirement on them versus encouraging them to do so?
The reason why I brought this bill, there were a lot of questions, and I had someone who was checking around in different areas, yes, on a peninsula, and it was not happening in one facility. And that's the reason why I wanted, instead of just continuing to poll the whole state, just based on those that I found out that they did not know and they were not providing that. I wanted to make sure that we put it in legislation, because it says the current legislation does not address this issue, prompting the proposal for this bill.
That's very helpful. Thank you so much, Mr. Chair.
Thank you. We have Senator Diggs, then I will entertain a motion.
Mr. Chair, I think Senator Diggs hit it on the head. This is happening in most places already, and people have a right to vote if they've not been convicted of a felony or if they've not had their rights restored. In most jails, this has already happened. And this is just clarifying, if anything. So I would make a motion to report.
Second.
There's a motion to report, and there's a second. Seeing no further comment, please open the vote.
Ayes 10, noes 5.
Thank you so much. And that concludes today's committee. We have 8 bills left in committee. Great job today, committee. Thank you.
The Senate of Virginia, Richmond, Virginia.